Hey, what's going on, guys? Welcome back. Welcome back to another one. The Young Thug trial takes a turn here. His attorney was arrested. Yeah, you heard it here. His attorney was arrested and for contempt of court. And also, Mr. Steele, before he left the court, he said before the judge, my client doesn't want to continue without me. And he was like, I want to be here, but you're holding me in contempt and you're taking me away. I move for a mistrial. I think that's his strategy, in my opinion, that he wants to try to get this case thrown out. And so yeah, he was held in contempt, and we're gonna watch it right now. For those who's watching the rebroadcast, please give us a like. That'll be greatly appreciated. Also subscribe, hit the bell notification so you can get updated on my latest content as it drops. I haven't been making much content over here. I've been over at my other page like that, but I'm gonna be covering this trial from time to time. So let's get on into it.
You all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again? Respectfully, I will not. I cannot. Sir, you have. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this.
He said you're trying to extort the court. He said, I'm not going to move forward if I don't get this and this.
It doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there's any accuracy to some of the information that we.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. That's not what happened.
Yeah, I think they're trying to move for a mistrial here. That's the strategy. But whatever it is that they are requesting, they're standing on it.
That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then you made no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Take Mr. Steele and he going into custody.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
It's something else, man.
Yes, sir, you certainly may. Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're
conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
All right, so I'm pretty sure this is not going to go away. He is going to, at some point, this is going to come back. I'm pretty sure of it. But I think they continue today. I think they continue without him, if I'm not mistaken.
We're going to be in recess for the next 5 minutes.
All right, so there it is right there. He let me see if yeah, they're live currently right now. Let's see if Mr. Steele is excuse me, let's see if Mr. Steele is back. No, he's not. He's not there. Yep, he's not there. Who is this on the
Permission to
stand?
approach, Your Honor.
He looked like he don't want to be there.
I'm showing you what's marked as State's Exhibit 358 Yankee and 380 Yankee. Starting with 358 Yankee, do you recognize anyone in State's Exhibit 358 Yankee?
Yeah, me and my son.
Okay. Is that the person that you've been referencing as Little D?
Yeah.
All right. And looking at 380 Yankee, do you recognize the individuals in State's Exhibit 380 Yankee?
You said what now?
Tell me who you recognize in 380 Yankee.
Oh, me and Coco.
Who's Coco?
The ugly boy right here.
Okay. Do you see the person that you said is your son, Little D, in that picture?
The restaurant got their head down.
Okay. Your Honor, this time the state would like to tender State's Exhibit 380 Yankee and 358 Yankee into evidence.
Little D.
You said 380 Yankee?
Yes, Your Honor.
And what else?
358 Yankee.
This trial is lasting a very long time, and I'm thinking at the end, I don't know what's going to happen at the end, but
Any objection?
I don't think
380 Yankee or
Young Thug is getting out of this one.
Yankee?
I just don't.
What about 358? All right, 358's admitted. Let me see 380, please.
And I can lay a little bit more foundation for 380 Yankees.
All right.
As far as the hearsay.
Okay, let me then go ahead.
Mr. Copeland, have you previously had an Instagram account?
Say that again?
Have you had an Instagram account?
Yeah.
And how many Instagram accounts have you had?
I don't know.
Okay. How many different names of Instagrams have you had?
2.
2. Okay. Has one of your accounts been 372 Woody?
I can't recall.
You can't recall. Okay. Are you
72
Woody?
Woody.
That's what they call you, right?
For sure.
All right. And do you know any other Woody who hangs with you? Is there anybody else in your friend group that they call Woody?
Yeah.
Oh, how many other Woodies are there?
Just me and the other one.
Okay. What's the other one's real name?
He died too. I don't know his real name. I think it's
He died too.
I know his last name Bridges.
The entertainment industry need to be ashamed of themselves, man, for letting these people out here like this.
I can't tell because
Promoting
the other guys got their head
promoting
down.
this bullshit.
Okay, well, just look and see if you see someone who looked like the other Woody, even with their heads down.
Can you show me a clear picture?
When you say clear, what's not clear?
Because he got his head down, he got his head down. My hand covering his face.
Let me ask you this. When did the other Woody pass away?
Right before I got the feds.
When you say right before, meaning that year, a few months, what do you mean?
I got it like September and somebody killed him, like probably, I don't know when, but they killed him before I got out.
Before you got out. Okay. All right. Looking at State's Exhibit 380 Yankee and looking at that picture with the 372 Woody, is that from your Instagram?
You talking about the one with all the people in it?
Yes, sir.
Okay.
Is that from your Instagram?
I don't recall this Instagram. My Instagram is Woody versus Woody.
Is that your newest one?
What you mean?
Is that the one that you currently have right now?
No, the one I currently have now is Woody _ self-made.
Okay. So are you saying you don't know if that's your Instagram?
I don't recall this Instagram.
You don't recall that Instagram? Okay. You're right.
If it's mine or not, I don't know nothing about it.
Okay. But do you see yourself in this picture?
Which picture?
The picture that's posted on this.
Yeah, I'm saying right there, ain't it?
All right. And right here, you can't tell if you see the other Woody.
I can't. I can see me and him real clear. Both of us got our heads up.
All right. Your Honor, again, say we will still like the tender State's Exhibit 380 Yankee.
Let me see it, please.
Here's my thing. If he's so uncomfortable being there, why is he there? Why don't he just say, you know what, I'll take my time. I'm not testifying. These guys are weak, man. Like most all criminals. Woody self-made.
All right, any further objection to 380 Yankee, sir?
There go Mr. Steele there. I guess that was before Mr. Steele. Well, he's back now. Maybe he's out of custody. I mean, maybe he only got detained for a little bit. Because this is currently live. All right. So they're talking over something right now. Woody don't want to be on that stand. You hear me? Woody do not want to be on that stand. Like I said before, like the entertainment industry, they put all this garbage out, this like drill rap type of stuff. And a lot of these guys are going down. It's like they're trying to clean it up a little bit, but it's still out there. It's I don't know, man. I don't listen to any of it. The drill rap and all that stuff. Young Thug. I can't even understand what he's saying anyway. To even listen to his music. But the judge is about through with everybody.
The published once it's submitted with the court's ruling.
Mr. Sharp, any further objection to state's yeah, 380.
All right. First, we're gonna publish 358 Yankee. And looking at 358 Yankee, can you tell the jury, tell the jury which of the two of you is little D or who you call your son? Which one? The person to the left of you, right of you?
What you mean?
Is that little D to my right?
This little D in the picture with me.
Okay. And
What
do
you
know
mean?
about how long ago
You
you
know
took
what
this
she
picture?
meant.
No, I don't.
And we keep saying little D or your son. Do you know his given name? His real name?
No.
Do you know his real first name?
You said you meet Young Garlington.
Okay. And is that the person that you know is little D?
This little D right here in the picture with me.
And is that Demekion Garlington?
This little D right here.
Is that Demekion Garlington?
If this was your name, then yes.
Okay.
See, he trying to
Now showing you.
act
380
like a certain way because he don't look like no snitch. He up there testifying, so
Can you zoom in?
he might as well just give her what she want at this point. You are up there making statements, sir. If it got too hot in the kitchen, you don't want all that time.
Now looking at 380 Yankee, is that you sitting on the step in a white t-shirt and blue jeans and black and gray
What you
sneakers?
mean?
Yes.
Okay.
Yes.
And who's the other person you said that you knew in this picture?
The ugly boy right here.
Okay. And what is that?
Ain't ugly.
What is the individual that you pointed to? What's their name?
Coco.
All right. And in this picture, the person behind you with the 30 deep B. I think it's BITXH shirt on. Do you know who that is?
I can't recall who that is.
You cannot recall. Does that look like Demekion or Little D?
He
Does
know
that
who
look
it
like
is.
Little D?
The head cut off.
Okay. If you could, can you turn your chair around and look behind you?
He gonna say he can't see it.
What about?
Does that look like Little D?
I guess.
Okay. Well, is someone you call your son? Does it look like the person you know
I
to be
can't
your
see
son?
that far. I just told you that from the beginning.
See,
Okay.
I can't
All
see
right.
that far now.
What, if anything, are you doing with
I can't see that
in this
far.
picture?
I don't know. I can't see that far.
No, nothing with my hand.
Okay. I want to go back to 358 Yankee.
He trying to act stupid. He on there. He making statements. I know he uncomfortable, but he chose to get up on that stand. So he got to do what he got to do.
What, if anything, are you doing with your hands in 358?
And what he doing with his hands?
What you mean?
What you mean?
What,
Like what
if
you doing
anything,
with your hands?
what you're doing with your hands
sign
symbolize,
language?
if anything?
A bird.
Okay. Does it mean anything specific?
No, throwing up a bird.
Why are you throwing up a bird in this picture?
Because I'm from Mechanicsville.
Is that the symbol for Mechanicsville?
We represent a bird.
Okay. And then what about Demekion? Are you familiar with the hand gesture that he's using?
I'm from Richmond.
Say that again.
Are you familiar with the hand gesture that Demekion is using? And
No, I don't know what
Bullshit,
that for.
man.
you don't. Okay. How is your relationship with little D today?
Meaning?
Do y'all still have the same relationship that you had
He
back
trying to
in,
act
say,
stupid.
2015?
No, we don't.
How has it changed?
I wanted him to lie for me, and he wouldn't.
Okay. And when was that?
Back in the day.
Back in
Say
the
back in the
day.
day. What do you mean?
When the police was accusing me for stuff, I went to Lil D and told him what I wanted him to tell the police, and he went to tell the police that, so I got mad at him.
Okay. And what year are we talking about that this occurred?
I don't know.
Are you speaking about one specific occasion or just multiple times?
No, I'm talking about one specific occasion, however you pronounce it.
I know he feel uncomfortable. He's sitting there testifying, and he got everybody
And
looking
is
at
your
him.
testimony that you have not been friends with him since that time?
Now, I have spoken with him, but our friendship ain't been the same.
When you think about your friendship with Demekion and your friendship with Shannon, at this point, who are you closer to, Shannon or Demekion?
Myself.
Okay. But outside of those, I'm speaking specifically about those two individuals. Between Shannon and Demekion, at this point, who, if either of them, are you closer to?
I don't understand what you're trying to say.
You and Demekion that's like your son, right?
Right.
And you said that the two of you, Your Honor, I'm just trying to clarify for Mr. Copeland. You consider Demekion like a son. Is that fair? Who are you closer to today? Demekion, Shannon, or neither one of them?
God.
Okay. That's good that you're close to God, but I'm talking about
He said God.
Demekion, Shannon. Who are you closer to today?
Oh my God.
Demekion, Shannon, or none of them, or neither of them?
I guess neither. I don't know how to answer that.
I'm close to God. What a clown that's on the stand. What a clown.
Back in 2013, 2014, 2015, that's the time frame we're talking about. How close was the relationship between you, Shannon, and Little D?
It was difficult.
You said it was difficult?
Right.
How was it difficult?
You just put 3 years together. So a lot happened within 3 years.
So
a lot
let's
happened
first
within
start
3
with
years.
2013.
You know what I'm saying? A lot happened within
Describe
3
for the
years.
jury your relationship with Demekion, Shannon, and Little D.
This
Let's
guy's
start
a
with
clown,
2013.
dog.
Tell the jury about your friendship and relationship with those two young men back then.
As in what?
Were you three of you close? Were you not close? Tell the jury about your friendship.
Look, I took special ed classes. You got to talk to me in a way that I can understand.
Sure. Back in 2013, were you friends?
Wait a minute.
With
Wait a
both
minute.
Little D and Shannon?
Yes.
I took special ed classes. You gotta talk to me in a way I can
How close
understand.
were the three of you back in 2013?
You took special ed. I took special ed class. Not special ed, special ed.
My friend was killed. That's when I started embracing little D.
All right.
In 2013.
When you started embracing little D, were you and Shannon friends at that time?
Me and Shannon was friends, but me and Shannon was not together on the street as much as friends. We was not together a lot.
Okay. When did you, little D, and Shannon start hanging together?
He's not stupid.
A lot.
He's just trying to act stupid. Somebody he took special ed classes. Clown.
Did you, Shannon, and little D hang out together?
Bad that he's snitching.
When did the three of you start hanging around each other?
Guys,
the longest I've been out of jail was 2014.
Special ed. Y'all remember the rappers?
To your knowledge, did little D and Shannon strike that? How did the three of you all start hanging out together?
I don't know.
Okay. Did you introduce little D to Shannon?
No.
Did you introduce Shannon to little D?
Guys, I'm gonna let this play out for a little bit.
Okay. Did little D and Shannon know each other before they knew you? Do you know if they knew each other before they knew you?
I don't know. I don't recall how it started. I just know I started embracing DB, Lil D, after DB got killed. Lil D was more a DB friend.
After DB passed, you embraced little D. Did the two of you start hanging out with Shannon after that?
I just said, how could I say this? Me and Shannon wasn't together in so long to be on the street. So I don't know when our three of us was able to get together. I just know at one point we used to go to the club together.
Did y'all do anything else besides go to the club together?
Yeah.
What?
You went and chased bitches. They having another sidebar convo. Hope everybody is well. If you're watching a rebroadcast right now, please give me a like. That'll be greatly appreciated. Also, subscribe, hit the bell notifications, and get updated on my latest content as it drops. All that'd be greatly appreciated. Give a brother a like, man. Give a brother a like, man. Stop giving me a hard time for the March of Dimes. Give me a like. Thank you in advance. One more time for the March of Dimes. Please give me a like. For those watching the rebroadcast, I appreciate you. All right now. But yeah, so I'm just gonna let this play out, and I don't know when this is gonna be over for today, but when it's over, I'm gonna come back with this. That's when you'll see it.
Would hang out.
All right, here we go.
Did you all spend time at each other's homes?
No.
Okay. Did you all spend the time at other people's houses together?
What you mean?
Like, did you all go to other people's houses and spend time at other people's houses together?
We didn't spend time at people's houses, but we don't been, we go to people's houses.
Okay. You said you went to the club. Would you all go out to eat together?
Yeah.
Did the three of you go on any vacations together?
No, we don't do vacations.
Okay. Did you ever take any trips out of town together?
Not that I recall.
Were you familiar with any of Demikion's family? His mom, his
I know his
cousins?
mom.
What about Shannon? Did you know his grandmother or any of his other family members?
No, I didn't.
You have children. Did they have any type of relationship with your children, Little D or Shannon?
No.
Okay.
Not that I know of.
All right. What about you? Did you ever spend time? Let me back up. Did Little D have children?
Ain't no telling.
Okay. To your knowledge, does Little D have children?
Not to my knowledge.
All right. To your knowledge, does Shannon have children?
I think so.
Okay. Have you spent time?
Well, Shannon have children.
Yeah. Have you spent time with his children?
I have.
Okay. Have you taken them to birthday parties?
But my relationship with his children is not through him.
Okay. Who's it through? Their mother?
Yeah.
Okay. No permission to approach? Show it to him now, Your Honor. You have to look at this one. This one.
Another sidebar. So Attorney Steele, he wasn't in, of course, Attorney Brian Steele wasn't in custody for long. So there's a lot of stoppages in this trial, man. Young Thug.
Mr. Copeland, I'm going to show you what's been marked as State's Exhibit 355, Yankee.
You're going to play stupid again. Up there giving statement.
357 Yankee.
What kind of gangster is this? Let me stop. I'd probably
345
be up
Yankee.
there too. I'm not trying to get all that time.
346 Yankee. 359 Yankee. And 374 Yankee. First, I'm going to start with 345 Yankee. Can you tell me if you recognize anybody in State's Exhibit 345 Yankee?
I can't recognize nobody in 345.
Do you see yourself in 345 Yankee?
The picture blurry. I can't recognize nobody in the picture.
I told you he gonna try to play stupid, like he don't know.
Okay.
I told you.
We'll come back to 345 Yankee.
I told you.
I'm now showing you what's been marked as State's Exhibit 346 Yankee. Tell me if you recognize Exhibit 346 Yankee.
Probably not.
It's blurry as well.
It's blurry.
Okay, so you can't see that. All right.
Mm-hmm. See, he trying to save face, like, but he's still giving statements.
Looking at 355 Yankee.
That's
Tell me if you
blurry.
recognize
I don't understand it.
the individuals in 355 Yankee.
Especially it.
I do.
Oh, he
How do you recognize the people in 355 Yankee?
Because it's me.
And who else? Is there anybody else that you know?
Shannon.
Okay.
Shannon.
Anyone else?
Yeah, and D.
Indeed.
All right. Your Honor, this time to say like 1060 with 355
Up there
Yankee
telling.
into evidence.
Trying to act stupid. Up there telling. He gotta feel uncomfortable though. I give him that. He gotta feel uncomfortable, but he's trying to get out all that time.
Yankee. Do you recognize anyone say exhibit 357 Yankee?
I recognize myself.
Okay. Do you recognize anybody else?
I said
It looked like D, but it blurry. I can't
it
tell.
looked like D, but
Okay.
it's blurry.
Anyone else?
Huh?
Anyone else?
Hi.
Yeah. I can't tell who this is right there.
All right.
Yeah, you
Put that in the blurry pile. We'll get back to that. Next, 359 Yankee. Do you recognize anyone 359 Yankee?
Yep. Me, Shannon, D.
And Shannon D.
You're right. This time to stay with like 1060 exhibit 359 Yankee. Thank you, Your Honor. And then last, stay exhibit 374 Yankee. Do you recognize anyone 374 Yankee?
Do you?
No, it's blurry.
Okay,
Yeah.
so that's in the blurry pile. Court's indulgence for one moment.
Let's see what the lawyers question him on.
Your Honor, permission to approach the laptop.
Maybe Steele was still allowed to stay in the courtroom, but he's not approaching. I don't see him up there approaching, so maybe they just allowed him to stay for this. I don't know. See, one guy over there look like he's asleep. Got his hand on his head resting. His head resting on his hand. No, he's not asleep.
I'm going to show you first, things first. I want you 345 Yankee?
To my this?
Yes. Does that say 345 Yankee here?
I guess, yeah.
Okay. Does that appear to be the same picture that's printed out on that paper?
It looked like it.
All right. Have I just made it bigger for you?
What about it?
Are you able now that it's bigger, able to identify the individuals that's in 345?
And what you asking me?
To identify
In 345.
the people in the picture.
Nobody.
So you don't see yourself in here?
To my this in this
In
picture?
this picture right here.
Yeah.
This photo me?
Does it look like you?
I ain't never seen this picture before, so
Not that it's seen it before. Does it look like you?
yeah.
Okay. Do you see anybody else that you recognize?
He playing stupid.
I think they Lil D.
Okay. Does it look like Little D?
Mm-hmm.
Mm-hmm.
You got a yes for the record. All right. Do you see anyone who looks like Shannon?
No,
No.
they Lil Rick.
That's Lil Rick. Okay. Is there anyone else that you may recognize in that picture?
Little Rick.
Done.
Done.
Okay. Anyone else?
That's it.
You say Dodd or Dot? For the record.
Who?
The person that said, what's the name you just said?
Done.
Dot?
Yeah.
D-U-N-T?
Yeah.
You're on this side of the state like 10 to 6 to 345.
Come on, he's special ed, but he know how to spell done. He playing stupid, folks. He just uncomfortable sitting on that stand, which I understand.
And I have a response to Kim.
Done. And just let it play out, folks. See what they talking about. But for those watching the rebroadcast, you watching live right now, please give me a like. That'll be greatly appreciated. All right.
All right, let's take 10 minutes and then we'll see where we are then. See where the day leads us. All right.
I got a headache.
We'll be in recess 10 minutes.
I might take the fifth.
All right, so jury. Our jury for President County Clerk.
All right, ladies and gentlemen, please be seated. All right, ladies and gentlemen, jury, how you doing? All right, listen, it's as you can see now, the hour is almost 6 o'clock, and there's some things we had to take up. So we're going to recess for the evening. Okay, so tomorrow morning, 9:30 for an anticipated 10 o'clock start time. All right, any ministerial inquiry of me? Okay. All right, ladies and gentlemen, let's go through your customary nightly admonitions. Okay, remember, as you leave here today, remember to leave your notepads in the basket. Do not discuss this case in ones and twos or back there as you are in your in your headquarters at your deliberation room, or as you're going back and forth to your homes of residence in our great county. Also resist temptation as well to even as in ones and twos for you to discuss the matter. Remember, I told you that it would be a violation for you to recap or otherwise handicap the testimony as you sit back there, because remember, you can only consider this case properly and lawfully, bless you, at a time and place and space that the court kind of tells you you're able to authorize you to do that. Remember, you cannot seek the advice of any third parties, any third party websites, any research or reference materials, any other things that would allow any extra information. Okay. Remember as well that if anybody should talk with you about this case in your presence or hearing, you need to, of course, let myself and Sergeant Ingram know immediately. And remember, you cannot go by any scenes that may be depicted or may have been talked about during this case at all. And remember, you can't take any pictures, discussions, or anything like that. So it's just that you're supposed to consider only what's been presented in this courtroom. All right, ladies and gentlemen, as well, thank you for your patience. Thank you for the attention that you've given this matter and the attention and patience you'll continue to give this matter. And unless you have any other ministerial inquiry of me, I'm going to release you till tomorrow morning at 9:30 for an anticipated 10 o'clock start time, okay? All right. All rise for our jury. Excuse me. All right, Mr. Copeland. Sir, over here. Over here. It's me. The state has filed an order of request asking that you be relieved of your custodial portion of this particular contempt on the condition that you just continue to come back and give your testimony, okay? So I will release you from the custodial portion as long as you come back tomorrow morning. Fair enough? If you're not willing to do that, I'm gonna leave you where you are. So the choice is yours, sir. The state's asked me to sign the order saying, hey, if you'll come back tomorrow morning, all I want to know is that that's the case.
I'll be back.
All right, 9:30 tomorrow morning, okay?
All right.
All right. All right, we can let Mr. Copeland be released and processed. Say again? Yes.
I'm weak, man. Y'all see me when I get out.
You go like this. Right. You can see him. All right.
That order, I'll go ahead and sign it, and I'll also make a copy of it as the next court's exhibit in order, and we'll e-file it this evening, okay? All right.
Guess they're almost done. We'll see. It was an eventful day, though.
Okay, Mr. Steele, are you willing to tell me at this point in time who it is that disclosed this information to you?
Unbeknownst to me, Gactyl is here, but they're not being allowed into your courtroom. I presume they're outside. So I'll wait on them to come in.
I'm asking you, sir, because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers.
Well, I didn't call them, but.
Okay, I mean, and that's,
Let me just finish.
okay.
You said to me that you figured out somebody told me this information, and you somehow said that it's privilege, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. But they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just.
Or they're not in your courtroom.
We just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that we'll fill up our benches at this point in time, that won't violate our security protocols, but that 8H is available. And
8H then has to have a right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's the president.
Okay, all right. Well, we'll let Ms. Merchant in.
That's
fine.
crazy. He needs his attorney there.
Yeah, Ashley Merchant.
He was taken into custody earlier, but then he was allowed to come back in the courtroom. That's what happened.
Ms. Merchant, good to see you as usual. I have told your client, you represent Mr. Steele, is that correct?
Yes.
For the purposes of the contempt, I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no supersedeas bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So he can, I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court, and it's very, since it was a ex parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
Let's see if he's going to tell him.
Judge, can you come up to the microphone? Sorry.
Please.
Where would you like this?
Microphone, it'll pick up, madam.
Thank you so much. Just for the record, Ashley Merchant.
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. That I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list and notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I won't disagree with you, but
well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215
215
Georgia App
Georgia App.
372.
Okay.
Also 215 Georgia App 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those.
Okay, so they're gonna probably need another judge to come hear this, because he's trying. Because if he doesn't give up a name, he's trying to take him in custody after this.
You have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older. But I do have other cases.
Yeah, he's trying to take him into custody if you don't give up this name. This is something else. So Young Thug's lawyer was held in contempt earlier and was taken into custody, but he was allowed to come back to court.
There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I have space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their names.
He still would have to be searched. He still would have to be subject to the court's protocols.
And also, there's room in the jury box, and then there's room in the courtroom. So we would ask that they be allowed to.
I don't want them in my jury box. Okay. No.
I understand.
Yeah, this is going to turn into something, folks. He's going to really push hard to try to get this case thrown out. On technicality, probably.
May one additional attorney come in, then Alex Susser. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
Yeah, I certainly may. Sure.
Great. Alex Susser. Alex Susser.
See, they were already prepared for this. He already had his lawyers ready to go because he knew, I guess he knew what he was going to do today. That's what I think.
It has two issues. One is the motion for disqualification. Okay. And that's, and I think the judge went ahead and did some other things that caused there to be that issue presented. So I don't think, Adam, I'm gonna take a look at the other case. That was Henry Adams. That was 215 Georgia 372. I'm gonna
Yes.
look at the other case just a second.
And there's several others when you're ready.
He already had this planned out. I'm pretty sure of it. See, they already hit the judge with this play here. They hit him with a play. That's exactly what they did. Because he already had these lawyers ready to go. She said she got over 20 lawyers outside waiting to listen in.
Yes. It may be one I have too.
Hasty's conduct didn't rise to a level in this thing warrant summary contempt by the court. That's the difference with Hasty than in this particular case. So
And
I distinguish your two cases that you've given me thus far.
so those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus State, it's 279, Georgia 13, 2005. It also,
You said 279 Georgia, what, I'm sorry?
Georgia 13,
Georgia 13?
2005 case.
All right.
And it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
See, but you all are covering under, let me see.
I'm sorry, Judge?
Hold on. Just a second. Pardon me. The contempt is directed. Trial court has the power after confording the contemptor to opportunity to speak and in his own behalf, announce punishment summarily and without further notice or hearing. I already did that, Mr. Steele. He's already told me. I already gave him the opportunity to do that. So we had that conversation this morning already. So
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm gonna disagree with you. Okay.
I believe that the court has put him in that position.
No,
he cannot be held in the law states McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder, obstruct the orderly process of the administration of justice. The preservation of order and decorum in the court is exempt from due process requirements of notice and hearing. That's even Moody. It goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him this to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merton, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them by nature.
Okay. Well,
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
but you got the
summarily
information.
hold him in contempt.
Here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge, there's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge.
They rolled a play on him.
He has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact or has filed, and I will note this as part for the record in this case.
So he going to jail tonight.
He has filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
You don't get a superseded bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
just the case law on that is in Ray Hughes.
Hold on.
Right.
They tried to run a play on this judge, folks. So they're going to try to get this eventually thrown out on technicality, but they trying. That's just my opinion on it. They were already
Supersedes
prepared
bond
for this
requirement
today.
does not apply in the contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So you don't get a supersedious on that, on a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, and that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that in fact I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Which is, I think I'm addressing a slightly different point of law.
It is. Hold on. Give you two cases. One is it's Untema. It's a UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the differences between the types of contempt. And then there's another case that I'd invite your attention to, and that is Henry Syverson. It's SYVERTSON, and that is 368 Georgia Appeals, Georgia App, I should say, 865. And that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other,
I'm not going to grant him supersedious.
and so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and a $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he, when he tells me what the basis of the conversation was, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
Judge, and that's respectfully, I would point you to N. Ray Hughes, which stands for the same point of law.
They bombarding him right now.
Punishment as a means of coercing future compliance with the prior order of the court. Here, the prior.
I really like
the
the play they running.
that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and a $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt. And that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who the person, okay, I'm sorry.
Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out. I'm gonna think about it.
Thank you.
Okay, all right. So we'll be in recess about 5 minutes.
All right, yeah, he got to think about this one because they bombarded him with a play here. They really did. Is it civil? Like he's holding them. It said it's criminal, but she's saying that it's civil, and they would like another judge on this because he's a witness. It was a marvelous play they ran here, I believe.
All right, thank you, madam.
Yeah. It's what we use in our bonds.
Sergeant Brown, is everybody present? Needs to be present? All right, thank you for your patience, counsels. The court's had an opportunity to reflect, and Mr. Steele, if I could ask you to take the podium, please, as well, and stand next to your attorneys. Okay, Ms. Merchant, Mr. Steele, and I apologize.
Mr. Susar, Judge.
One more time?
Susar.
What, spell your last name for us?
SUSOR, Sierra, Uniform, Sierra, Oscar.
You're a good man. Good man. Okay, all right.
Let's
okay.
see what he do.
All right. Thank you, sir. Okay, Mr.
The judge took a long time here.
I've made a clarification to the order of contempt. Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody and incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed. You may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, sir, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay? If that should occur. Okay? All right. Okay. All right. All right. Is Miss Councils, I'm done with this unless you have anything else. All right. Thank you. Thank you, Miss. Thank you, Miss Merchant and Miss Sisser.
Thank you.
Okay. All right.
So he's gonna have to do his time on the weekend.
Yes. In fact, the clerk is going to file a copy. It's going to be e-filed. It'll be on the e-file system momentarily. You should be able to get a copy of it from there directly, download from there.
And Judge, Ms. Merchant and I will file entries of appearance on behalf of Mr. Steele.
Sure, that would be great. Thank you so much. Okay, all right. All right, State, is there anything else we need to, or any defendants, is there anything else we need to take up before tomorrow morning? Mr. Copeland is going to rejoin us tomorrow morning, so we'll continue with his testimony. Where's Miss Bumpus?
Your Honor, I have a matter.
1 second. Where's Miss Bumpus?
Your Honor,
She hasn't been released yet.
I'm not certain, Ms. Hilton is attempting to determine her whereabouts.
All right, if you could call her, Miss Hilton. Thank you. All right, Mr. Sharp, sir.
Your Honor, I have to prepare for my cross-examination of Kenneth Copeland over the next few evenings. And I would ask once again for the court to release the transcript of what occurred earlier today so that I may prepare my cross-examination.
I'm not going to do that, sir. Not at this point in time, respectfully. Okay.
Well, Your Honor, respectfully, and if it's not released by the time that we cross-examine Mr. Copeland, our defense will be hindered.
Sir, that'll be an issue you can certainly raise then and now, but
Judge not having it.
I'll think about it. But at this point, I'm not inclined to release the transcript of the court's ex parte hearing because of the way it was the way it was disseminated. That's why I'm not inclined to do it.
And I would also, I understand the court's ruling. I would also ask for the release of any audio tapes regarding that hearing as well.
Well, the only audio tape that I know of is maintained by Miss Weaver, who tapes her proceedings in order for her to prepare a transcript. So, okay. Well, I don't know. She may not have any, but we'll see. Okay.
Good evening, Carson Matthews on behalf of Mr. Steele. We're making that same request, Your Honor, for that transfer. We potentially contain some Brady.
Sure. Okay. All right. Unless there's anything else, counsel?
I join that, and I also believe I advised the court the reason that I also want for confrontation cross-examination is supposed admissions Mr. Copeland made about our case outside our presence, and based upon information and belief, the court handed Mr. Copeland allegedly the long false swearing and perjury, and if that's true, I'd like to also talk with him, if he'll talk, about how that came about. I'd like to read the transcript. So I'm joining in, but also it goes to matters that are discussed about the case based upon information.
Madam.
Your Honor, there was no matter to which either counsel for either of the defendants was a party. There was no matter to which either defendant in this case was a party that was had or held outside this courtroom. So we would ask that the court deny what is being requested of the court, because that is something to which neither defendant is entitled.
Your Honor, the witness is on the witness stand. Your Honor, the witness is on the witness stand. The witness is testifying under the RICO Act, which covers all of the defendants. As I understand upon information, believe that which is the witness has stated again on Friday that he was not going to testify. Today, it was a different scenario. And based upon it, Your Honor, we believe that we should be entitled to that on the Brady, because we believe it's potential Brady material.
All right, sir.
And it's covered under the RICO. He's testifying against all of these defendants under RICO. So we all are part of this witness's testimony.
Your Honor, I would additionally point out that the question to which Mr. Copeland asserted a Fifth Amendment privilege was, how old are you?
On Friday.
Yes.
Yeah. All right. I'm going to deny your motion, at this time, Mr. Matthews.
Your Honor, I don't understand the state's argument that we are not a party. This gentleman was sworn in as a witness against all of our clients. He is sworn in as a witness specifically against Mr. Stillwell. Conversations with that gentleman were occurring apparently ex parte without our knowledge, without my client's presence. And I don't understand how the state with a straight face can possibly say we are not a party to matters concerning a witness sworn in trial to testify against our clients. We are certainly a party.
Okay.
And we were denied the right to be present.
All right. Thank you, sir. I'm still going to deny it. All right. Anything else?
Just we would ask for a copy of that transcript since it's germane to the contempt. So we will be asking for that in the court order as soon as this court order, since that is.
It's an ex parte matter, so you're not going to get it unless the appellate court wants to see it, if it's accepted. So, but I'm not going to give it to you at this point in time.
I assume the Harvey rule applies.
Yes, sir. All right. All right. See y'all tomorrow morning, okay? 9:30 for an anticipated 10 o'clock start time? Okay, we're in recess.
All right, so they're in recess until tomorrow. So I'm gonna try to record it all tomorrow and see what happens. So yeah, as you see that Mr. Steele was held in contempt, and he ruled that he took a little while on his break to make a ruling, and he ruled that he has to report to the county jail on Fridays, and he'll be released Sunday at 7 p.m. And Mr. Steele requested, while he's in custody on the weekend, can he be with his client to go over the case? And the judge said that was okay. So, and I guess at some point they will decide whether he get a bond or not. So we'll see. So that was kind of breaking news today. The Young Thug's attorney, Brian Steele, was held in contempt of court, and he was being held for a minute. He was requested to take his tie and his jacket off, and they took him away from the courtroom. But then he was allowed to come back. And then his attorney showed up, and she said there's at least 20 attorneys out there waiting to come into court. But the judge denied that. So the attorneys had to go somewhere else and listen to it. But he was prepared. I honestly think he was prepared for today, for this to happen, you know, to try to create some type of technical situation to get this case thrown out, or to get this trial to be a mistrial. But anyway, please give me a like if you watch this live. I will catch you on the next one. All right, guys, take care.